Jonathan's question about the slides that you see.
Yeah, I see.
You will see it here.
Okay, I think it's about time that we started. Well, good afternoon, everyone. Thank you very much for choosing this Agora for as a place for digesting your lunch. And I hope that you will find this discussion interesting and enjoyable. My name is Mykola Gnatowski. I am a judge at the European Court of Human Rights, and I am extremely honored to be here in the capacity of the moderator of this Agora. We have three. Well, so the topic pretty much continues what was already discussed at different fora here. And it concentrates on humanitarian law, humanitarian action, a little bit of disaster relief, so to say, but primarily humanitarian law issues and the application of modern technology to the situations arising from the armed conflict. So we have three speakers. We are very lucky. All the three speakers are with us. And that also, I think, confirms that this panel is a very special one. I will introduce the speakers in the order of appearance. So we'll start with a presentation from Dr. Agne Limante, who is a researcher at the Law Institute of the Lithuanian Center for Social Sciences. She will speak about the facial recognition technology in Russia's war against Ukraine. She'll be followed by Dr. Julia Ioffe, who is an associate professor in law at University College of London and an expert on child rights and migration. Dr. Ioffe will speak about genetic tracing, DNA testing, and forcibly transferred Ukrainian children. And then there will be an opportunity to zoom out somehow from these more concrete examples, and that will be done in the presentation of Professor Jonathan Heifetz from the Seton Hall University School of Law, who will discuss digital technologies and the reshaping of international humanitarian law. So we'll start, Agne, with you. The floor is yours. Yeah, I think all the speakers will have their PowerPoint presentations. You will be able to follow them on the screen and also here. Okay.
So good afternoon, everyone. First of all, thanks a lot for inviting me to this event, to this wonderful conference. It's indeed an honor to be here, and it's amazing how many of you are here and how many traveled from so far away. My topic today is Russia's war against Ukraine, a topic which already was touched from various perspectives. What I will speak specifically is facial recognition technology that is used by Ukraine in this war. Why this topic for me? So first of all, I based my research on a project which we had in 2021, 2023 on facial recognition technologies in law enforcement. And one of our products was to submit a book, a scientific book, to a publisher. And when we submitted the book proposal, the war in Ukraine started. The war started and all the technologies used in Ukraine was on the flashlight. So we were asked specifically by the publisher, Cambridge University Press, to include the topic on facial recognition technologies used in the war. It was a new topic. I did a lot of research and a lot of information was just repeating itself. It was very limited. So it's a bit reoccurring research for me. I started in September 2022, and then I came back to the topic again. Please understand the limitation of my research that given the continuation of the war, my research relies on the publicly available information, the information which I can access in Russian, English, or Ukrainian languages in public media, information I can access on the social media of the Ukrainian officials, so there is this limitation. Let me start by saying that artificial intelligence is in fact changing changing our world in unprecedented ways, and it is transforming many fields, such as whatever you mentioned, science, education, engineering, and even art. No surprise, it also affects the warfare. We had a presentation on the session on technologies in warfare by Natalia Hendel, who overviewed a variety of new tools that are being used currently. So there is no surprise, we call it now AI's Oppenheimer's moment. Russia's war against Ukraine has been labeled as such, and it's also named sometimes as Ukraine became like AI war lab. We have so many things being tested there. In this presentation, I will look specifically on how Ukraine employed the facial recognition technologies in the battlefield in Ukraine, how it could be used as investigative lead and future evidence before the court. And also, if I will have some time, I will mention the concerns associated with the use of facial recognition technologies in the warfare. If no, I will mention it during my speech. I am sure that most of you have seen in the world press shortly after Russia launched the large-scale attack on Ukraine, that already in February 2022, Clearview announced that it gives its facial recognition technology for Ukrainian government to be used for military purposes. Very fast, just mid-March, Ukraine's defense ministry is already acknowledging the use of this technology. It states that it's using it to identify soldiers, for the operational needs. So it comes very fast. You offer technology, it comes fast. It's a bit fascinating because when we talk about technology in peacetime and in the wartime, it's really different. In peacetime, we have time to discuss what is acceptable, what should be changed, what is acceptable for humanity, is it okay with human rights? At the time of war, it's a bit different. When Russian attacks were going on, Ukrainian officials and in general government had very little time to think of legal rules, to do the training of the people, of the military soldiers, of the police soldiers. All political debates, public scrutiny, academic and society discussions were not there. What Ukraine had to do is to defend its country. So what we had a collective effort, actually, an amazing thing, which probably unprecedented in certain way, that collective efforts of all Ukrainians, civils and military personnel to generate ideas. What can we do with this technology? How can it be used? That's how it all started. The first thing which we saw, the first idea, was identification of dead soldiers. Usually it was the Russian soldiers, and you might think, why would you need to identify a dead soldier of the enemy? It's not a priority, probably. But in fact, it served for two purposes. First of all, it was the idea to inform the families about the war, that the war is going on, that there is a problem, and the denial the Russian society had about the war was thought to be overcome. So overcoming propaganda and informing the families were the first idea. However, of course, there are questions whether this informing of families by sending them pictures of their beloved one, identified via social media and facial recognition technologies, is indeed acceptable, so this idea a bit controversial. We can also think about psychological violence or disregard of human dignity, humiliation of enemy. In any case, it was soon realized that maybe this effort is not so effective because the idea to overcome Russian propaganda was not working. Russians came back with anger, with aggression, and for those who follow social networks of Russians saw that it's not reaching its targets. There is a website, I put a picture on it. At the moment, it shows that there are 80,000 of Russian soldiers identified via this technology. Another thing, another possible way of use of facial recognition technology was identification and verification of people of interest. So checkpoints was one of the points where it was reported that Ukrainian government is using the facial recognition technologies. Again, we can talk about human rights here, but priority was to to ensure the safety of people. From one side, it could be a good idea, but again, you need structure, you need time to prepare. So I think though there is a limited information on that, and what I asked from my Ukrainian friends, it's also limited use on the checkpoints at the moment. Another I put as an example is AI-generated picture, of course, but there's also an example how a facial recognition was used. So there was a case where a Russian soldier was wounded, and he got to hospitals, and he claimed that he lost his memory, and he's Ukrainian. To check his identity, the facial recognition was run to identify him actually as a soldier of the enemy. So it also allows for usage in such environments. Identifying victims is, of course, what Ukraine is doing, same as with the dead Russian soldiers, but it also can help missing persons. Yulia will talk about it right afterwards, but it's also one of the possible situations. If you have a picture of the child, and then later on the child who is abducted to Russia and then given for, I don't know, whenever his picture appears online, there is a possibility to have it issued a sign saying that the person is there. So there is a possible way also to track people where they are. Again, you can think whether this is really acceptable, to what extent it complies with human rights, what are the risks. The risks, of course, are there. Let me summarize a bit that currently what we see is what is disclosed use of the facial recognition technologies is its non-offensive use. We have counterintelligence, identification of people, recognition, combating of misinformation and denial. But of course, it's not the end. Though we don't have it at the moment, hopefully, it's definitely coming to the future. The facial recognition technologies can be included in the drones. I've read it that in already 2023, US government contracted the supplier to develop such technology into drones. It might be that it will come in the near future. It's already there. Some of the drones can be AI powered. That's even more risky because then you don't have so much human control. There are a variety of other tools. Just to give an example, what fascinated me, I think you saw it a few months ago, Chinese developed gun-totic robot dogs, some monstrous futuristic dog-type tool that can go and shoot around. So add facial recognition technology and you have a killer robot. So there are a lot of things which are coming, which we really cannot stop so easily. They are being developed by one country or another. What we can do, we try to find possible rules. We can find the approach towards it, but it's coming, so we have to accept it. Let me continue now from the battlefield to courts. And the first thing to mention here is that the courts are using, of course, the pictures. What we have historically in prosecuting war crimes, pictures were used. Of course, it was real pictures and the other visual evidence. They helped to hold perpetrators accountable. They were useful for public awareness, human rights abuses. They have played an important role. However, this reliance on in war crime investigation on the visual evidence is, of course, increasing because what we have now is proliferation of the smartphones and the other technologies which allow every citizen to take a picture, to collect real-time footage and images, and there is possibility then, again, we are talking about the collective efforts to bring the responsible to justice by supporting the collection of evidence. So those evidence collected by private actors, ordinary citizens, NGOs, journalists, then become important, numerous, and also facial recognition technology can help here. It can picture what was happening, who was involved. So in general, for the crime investigation, it has a huge potential because it can automate the process of identifying individuals in photographs. It can work with a huge amount of pictures. It can single out the faces of interest, and collect from all the group of images that is held in the database. It can also support the verification and corroboration of witness testimonies. And also, if you identify specific soldiers, 1, 2, or 3, you can also connect them to certain military unit and its commands. So it also helps to investigate the case a lot. I don't have so much time, but I want to give you an example of a couple of first cases. As I said, I did a bit research into social media, and I think it's sometimes nice to see what are people speaking on this flash news basis. So in Ukraine, when the war started, one of the first funny situations was that the Russian soldiers were stealing clothes, for instance, or washing machines. This was something a bit funny in this generally dramatic situation. And what they did, when they went to Belarus, and then they shipped those things they have stolen to Russia. In Belarus, in some of the post offices, they had pictures, cameras, which took their photos, and then they were identified. I put a white circle on the face just in case they are missing, they might say identified. I'm not sure about that. So in May already, 2022, the Ukraine's digital transformation minister shared on Twitter and Instagram the pictures of people who were identified as stealing from Ukrainian homes and sending it to Belarus. So these are first pretty simple cases. The second picture is already of a person who is suspected to have killed civilian openly. On international level, of course, this evidence will also be brought at a certain point. It's coming. The digital evidence in general is accepted before the International Criminal Court. I think we're going to have about that also in the presentation that will follow me. OTP link also includes certain elements of facial recognition technologies allowing to sort the materials available. I would also like to mention here the Glukhin case against Russia. It was one of the first cases in the international sphere that considered the face recognition technologies. And the general acknowledged that such technology is acceptable if certain principles are complied with. Definitely in case of war, those principles would be pretty easily easy to implement. The caution related to facial recognition technologies is one and the main one. It can only be seen as investigative lead, but not as definitive evidence. Facial recognition technologies are pretty accurate, but they also give you only the certain percentage. If you run the picture via the system, it will show you what is the likeliness of the person being the same as you see. I don't know if you have seen it in the police reports, but there is certain, like, they give you 3 pictures and the percentage saying what is the chance that this is the same person. So there is always a chance that it is wrong. So in order to be sure that you are not trying the wrong person, you always have to verify that you have other tools to check it. So witness statements, other videos, communication with relatives, and so many other things have to be checked. It's not the main evidence and the main tool. I don't have much time, so I will just shortly, in 1 minute, summarize. So what are the main concerns with the use of the facial recognition technologies in the wartime? So first of all, the thing I mentioned, the false identification. While identifying a dead soldier, it's not such a big problem and the risk is a bit low. Of course, the distress for the family could be there. If you false identify a suspect, that might lead to much stronger and negative situations. There is controversial deployments such as killer drones, killer robots. This is the thing which have to be regulated, which have to be approached. There is another risk of misuse, of course, used for the other purposes than initially planned, unauthorized use when access is given to persons who have no right to use such technology. And one of the main concerns which continues after the war, what will be next? Once you get used to technology, you're not giving up on it. So once you have it, there is a big likeliness it will endure to the peacetime. And then the whole new set of problems come. What do we do? Do we want to be a supervised state? Do we want to have our pictures there? What will it be to the data collected already there, all the dead bodies pictures, all the pictures of the suspects or people crossing the border, what will go next? It's all in the system. So let me stop here. If you're interested to read more about facial recognition technologies, there is a book published recently. You will find also my chapter there. And thank you for your attention. I use the AI artist to help me to prepare the pictures.
Thank you very much indeed, Agni. Thank you. Thank you also for being very precise with the timing. And now the floor is for Dr. Julia Joffe, who will also speak about very concrete matters related to the forcibly transferred Ukrainian children and the application of new technology. Julia, you have the floor.
Perfect. Thank you so much for the kind introduction and also for opportunity to speak at this conference. As Inga foreshadowed just now, I will be speaking about genetic tracing, DNA testing, and forcibly transferred Ukrainian children. But I would like to start with some factual background on this issue. So since February 2022, from around 20,000 to 700,000 Ukrainian children, according to different sources, were forcibly transferred to Russia or territories temporarily occupied by Russia. However, this practice started as early as 2014, but definitely since 2022, it became systematic and extensive. And there are generally four categories of children that are forcibly transferred. First, these are children in occupied Ukrainian state institutions, orphanages, boarding schools, hospitals, even if these children have parents and families. Just to note that in Ukrainian orphanages, most children are not true orphans. Many of them have families and parents, but they're there for social economic reasons. The second category are children that temporarily traveled to re-education camps under the guise of holiday camps for a couple of weeks, but were never returned to their parents and families. The third category are children that were separated with their families and parents during the so-called filtration process. And finally, there are children who are captured on the battlefield when they are separated from their parents because they're lost or their parents or families have been killed. And the Russian Federation does not only forcibly transfers the children to the Russian territory or temporarily occupied territories. The Russian state also has adopted a policy aimed at indoctrination, the Ukrainization of these children, and also separation of the children from their families, communities, society, and country. And these efforts particularly include compulsory school education in the Russian language, Russian curriculum, refusing to provide education in Ukrainian language, Ukrainian curriculum in Ukrainian history and culture, efforts to hinder communication with children's Ukrainian families, including by changing children's names and dispersing them throughout the territory of the Russian Federation. Russia also adopted legislation that expedites adoption of Ukrainian children by Russian adoptive parents, and the Russian adoptive parents receive increased financial support if they adopt Ukrainian children as opposed to Russian children, and they're also provided with additional ideological education. And just to give you a concrete example of such efforts of hindering communication with families, this is the story of adoption of Margarita Prokopenko, and we only know about this example due to excellent work of investigative journalists, and this is quite a high-profile case. However, there are many such cases of which we don't know. In this case, Sergei Mironov, who is a member of the Russian parliament and also a leader of Putin's political party, and his wife adopted a 10-month-old girl, Margarita Prokopenko, a Ukrainian citizen, in orphanage in Kherson during its occupation by the Russian army. The girl was taken to Russia and her name was changed to Marina Mironova, and she became a Russian citizen. So you can see that the children that are forcibly transferred, they are of different ages, starting from a couple of months to 18-year-olds. And the question of DNA-led family reunification becomes particularly pertinent with regard to younger children children like Margarita Prokopenko. In the next section of my presentation, I will be talking about some international legal obligations that relate to missing persons and forcibly disappeared persons. In my view, forcibly transferred Ukrainian children fall within both of these categories. Considering that forcible transfers are happening within the international armed conflict between Russia and Ukraine, IHL applies, and both Russia and Ukraine are parties to Geneva Conventions and Additional Protocol 1. Of course, IHL includes rules that are designed to prevent forcible transfer of Ukrainian children. However, unfortunately, Russia has violated most, if not all, of these rules. For the purposes of this presentation, I'm focusing on particularly the rules in IHL that relate to right to truth. So the families have a right to know the fate of their relatives, as well as obligations on parties to a conflict to search for persons who have been reported missing by an adverse party. Similarly, there are a number of international human rights law provisions that are relevant, particularly the right to truth and the right to privacy, and potentially when we'll be talking about DNA-led family reunification of Ukrainian children, these two rights might come into conflict. So the most comprehensive formulation of the right to truth is included in the International Convention for the Protection of All Persons from Enforced Disappearance. However, it should be noted that Ukraine is party to this convention, but Russia is not. There are some related rights to right to truth that concern protection of family and a right to identity of children that might be relevant. And of course, the right to privacy is an established right in international human rights law. However, it's not an absolute right, and its protection is necessarily relative and can be limited in certain circumstances. And this right can be derogated from, and in fact, Ukraine has derogated from relevant provisions of ICCPR and ECHR with regard to right to privacy. And it should be noted that Russia is no longer part of the ECHR. Ukrainian legislation, of course, is relevant in these circumstances. Constitution of Ukraine includes a number of fundamental human rights, including the right to privacy, but you can see that it expressly provides for limitations for the reasons, for example, of national security. And I also would like to highlight Article 11 that emphasizes the state's commitment to promoting the consolidation and growth of the Ukrainian nation, including its historical consciousness, traditions, and culture. And I'm highlighting this provision because forcible transfer of Ukrainian children is seen in Ukrainian society and also by Ukrainian government as part of genocidal campaign by the Russian Federation against Ukraine and an attempt to erase Ukrainian identity, and also as a continuation of historical colonial practices of ethnic cleansing, deportations, Russification during the Soviet Union and Russian Empire. So you'll see already that there is a significant risk of conflict of the right of Ukraine as a nation of survival and also individual right to privacy of children that were forcibly transferred. There is a separate law in Ukraine on the legal status of persons missing under special circumstances that mandates the establishment of a special commission and also of a unified register of missing persons, and forcibly transferred Ukrainian children would fall under the purview of this law. Articles 21 and 22 specifically talk about the register and DNA testing, but it should be noted that this law and also many international guidelines that talk about DNA testing, they focus mostly on forensic evidence and retrieving human remains, so deceased instead of the living human beings. And a number of Ukrainian state agencies are responsible for accounting for missing persons, particularly the commissioner that I already mentioned, and the Ministry of Interior. However, previously this mandate was held by Ministry of Reintegration, but many other state organs and ministries are also have some authority in this area. Ukraine already established the unified register, and so far there are around 28,000 missing persons that are registered in the register, of whom more than 2,000 are individuals who are under 18 years old, but not all of these individuals are forcibly transferred children. Unfortunately, some of them are deceased or persons who were killed during the hostilities. Starting from November 2023, Ministry of Interior of Ukraine initiated a campaign to collect DNA samples from family members of Ukrainians who are abroad. The campaign is in coordination with the International Commission on Missing Persons, ICMP, and it started in Poland and Germany, and now it's expanded to other countries, including Moldova, Romania, Bulgaria, and others. And just to place these efforts in Ukraine in more international context, DNA analysis in identifying and recovering missing persons is not new, and situation of forcible transfer is also not unique to Ukraine. DNA analysis was first applied in mid-1990s, beginning in South America and the Balkans, but Argentina was the pioneer in establishing genetic database specifically designed to identify disappeared children. So I'll stop for a second to talk a little bit about the example of Argentina. As many of you may know, during the country's military dictatorship from 1976 to 1983, children were taken from their parents and placed with other families, following which grandmothers of these children started an association, Grandmothers of the Plaza de Mayo, in collaboration with the geneticists to create a national bank of genetic data where they donated their genetic material and also encouraged children who were at the time already adults to donate their also DNA samples in order to be reunified with their biological family. However, even though some children, or at the time already adults, volunteered to provide their samples and were reunited with their biological families and were quite happy about it, there were many cases of children, again, adults at the time, who didn't want to submit their DNA samples for two main reasons. First, they thought it was a violation of individual right to privacy, and second was because they didn't want their adoptive parents to be imprisoned because they did participate in illegal adoption. So there was quite an intense litigation in the country, but ultimately the DNA law was adopted that allowed compulsory DNA testing and prioritizing the interests of the state and society over the individual privacy rights of these children. So against this context and against the context of Argentina, I identified three categories of challenges or considerations: legal challenges, ethical challenges, and practical challenges. Ethical and practical challenges potentially might overlap, but I'll start with the legal considerations. First, there should be robust protocols in Ukraine for collecting and preserving DNA samples. This is for the reason that these samples might be used not only for identification of forcibly transferred children and family reunification, but also can be used in prosecution of international and other crimes before International Criminal Court and in domestic courts. So a certain standard should be maintained, so these samples can be used as credible evidence in court. Another big concern, of course, is data security. There should be a modern, secure program that helps preserve all this sensitive data. It seems that Ukraine collaborates quite closely with ICMP, and ICMP has a lot of experience in this area, and in the unified register that already exists, all these protocols and guarantees are taken into consideration. And finally, there is a question of conflict between compulsory DNA testing and right to privacy. It is possible that Ukrainian children, some Ukrainian children would have integrated already into Russian society. Some of them bonded with their Russian families, so they wouldn't want to provide their DNA testing to be reunited with their biological families. So we will have a similar situation as was experienced in Argentina, and then there will be a clear conflict between the right to privacy and compulsory DNA testing. Here, a couple of elements might make a difference. So the age of the missing persons. So if these individuals are still children, children have generally less of an expectation of privacy, and it might be argued that best interest of the child require children to be reunified with their biological families and their Ukrainian culture. But at the same time, if these children are adults, depending on how long the war continues, then it will be much more difficult to compel the adults to provide DNA samples. And again, depending on whether the war ends or not, and Ukraine is no longer derogating from right to privacy, then it definitely might be a legal problem. With ethical considerations, trauma-informed protocol should be observed. There should be a cultural humility in approaching the families, and relatedly, families should have a central role in acquiring information about missing persons. This at least is informed by the experience of Bosnia and Herzegovina, Argentina, and Colombia. And the trust of general public is needed for the DNA-led family reunification. The public should understand the procedure, and these expectations should be set. And finally, there are three practical considerations that are important to take into account. First, the collection of large number of DNA samples. To just give you an example from the experience of ICMP, to account for missing in Western Balkans, to account for 30,000 missing in Western Balkans, they had to collect 100,000 DNA samples. So in the context of Ukraine, this would be the similar numbers. Second, there is, you might have seen the conflicting administrative competencies within the Ukrainian government. So there is some bureaucratic inefficiency and overlapping mandates and jurisdictions. It would be great if there was one organ with clear jurisdiction that has authority over this issue. And finally, the question of cooperation with international bodies. ICMP and Ukrainian government has a great cooperation. However, for example, ICRC, that it should be involved in family tracing and family reunification. The relations between Ukrainian government and within Ukrainian society are difficult towards the ICRC. I'll stop here, and I'm looking forward to your questions. Thank you.
Thank you very much indeed, dear Julia, for your presentation and also for being very precise with the timing. And last but not least, and I think it's really important that now we listen to Professor Heifetz, who will essentially zoom out a little bit, but at the same time, you will see that his points are very much linked to the presentations that we have just had from Agne and Julia. Professor Heifetz, you have the floor.
Okay. Thank you very much. So I'm going to talk about digital information narrative and reshaping of international humanitarian law. As my co-panelists and many others have talked about over the past day and a half, digital information, capture, generation, spread, analysis, through digital technologies has significant implications across a range of areas. And I'll talk in particular about implications for international humanitarian law, which of course is the rules that seek to limit and prevent human suffering during armed conflict, and then for international criminal law, the branch that defines international crimes, including those committed in armed conflict. Uh-oh. There we go. So digital technologies have a number of implications or components. One is the making broadly available through smartphones, other technology, the ability to capture what's happening on the ground. The technologies transform or enable just anyone to record or document, and everyone becomes, a potential human rights researcher. Not only is it the ability to capture, but also to share information about armed conflicts and atrocities instantaneously. And then there's the ability to aggregate and analyze the data. And these are, these are significant developments. All of these things have been done before, but it's just a transformation in the capacity to document, record, and analyze information about armed conflicts. So what I want to really do is to talk about some of the implications for international courts and the prosecution of atrocity crimes, and the way in which digital information, how does it affect narratives about armed conflicts, both through courts and outside of action by courts. So those are a couple of the key themes, and I'll come back to them at the end. Just a little bit of overview before, in terms of kind of looking chronologically at what's happened. Just talk for a minute about Syria, which was the first war that was extensively recorded through the new and widely available technology of smartphones and distributed through social media. So it was, in that sense, kind of a key turning point or key event. You had crowdsourced digital information, text, photos that created a visual map of casualties and war crimes. You had tools of data mining, machine learning algorithms to analyze the growing body of information. And then you had efforts, including by Syria Justice Accountability Center, to capture, store, label, process, analyze this for investigations of human rights violations and international crimes, and ultimately one day to preserve this evidence for prosecution. These trends, the technology that was available during the war, during the peak of the war, has just accelerated, and we now have digital evidence being relied on increasingly. So at the ICC, we have the Al-Warfali case, which was the first time the ICC relied on user-generated digital footage, cell phone videos, to approve the issuance of an arrest warrant. The Al-Mahdi case, it was used for, videos were used for a prosecution for destruction of protected cultural heritage. We've seen use at the ICJ. Video evidence was cited in Ukraine's suit against Russia for failing to suppress terrorist financing in eastern Ukraine and the Crimean Peninsula. Facebook evidence was presented in the Gambia suit against Myanmar for genocide against Rohingya. And I think probably at Gaza, widespread use of digital evidence. It was used by the UN Commission investigating the October 7th attacks on Israel and the subsequent war in Gaza, Israel's military action in Gaza, satellite imagery, forensic medical records, open source data. So you have all the digital information, and then you have the reliance on it by NGOs, media outlets, and the like. And the commission pointed out the importance of digital information given the significant challenges investigating acts committed in Gaza due to the scale, the continuing nature and scale of the violations, Israel's refusal to provide access to the Gaza Strip, and the overall security condition. And we can see the role of digital information, digital evidence in the ICC's issuance of arrest warrants for Israeli Prime Minister Netanyahu and Defense Minister Yoav Gallant, and for leaders of Hamas. The ICC, the chief prosecutor, did not specifically cite evidence in announcing the arrest warrant, but he did refer to such evidence, including CCTV footage and authenticated audio, photo, and video material. The expert panel that was convened to support the investigation also indicated that it had reviewed authenticated photos, videos, and other digital evidence. Digital evidence played a significant role, or is playing a significant role in South Africa's action against Israel before the ICJ under the Genocide Convention. South Africa relied extensively on digital sources media articles, as well as media articles in UN reports, many of which themselves rely on photos, videos, other user-generated evidence. There are citations to statements by Israeli officials on social media to try to show genocidal intent in support of the application, and as well, and significantly, the volume of digital evidence to show the nature and scope of the humanitarian catastrophe in Gaza and Israel's role in it, which played a role in the issuance of the various preliminary measures. So just to talk a little bit about some of the benefits of digital evidence, as I mentioned, it decreases the need to rely on professionals to access crime scenes. And it's particularly helpful when investigators face risk due to violence, as well as because of limitations on access. It democratizes evidence collection, allowing a broad range of individuals, journalists, advocates, victims, ordinary citizens to document war crimes and disseminate that information. And it promotes the development of tools by courts to collect, analyze, and authenticate digital information. And we've seen a number of different steps taken, for example, by the ICC, both to create a portal for the submission of digital information, as well as for its Project Harmony, the ability to analyze that information. So significant benefits, potential advantages of digital evidence for courts. At the same time, there are a number of challenges that are posed by digital evidence. So one is disinformation and deepfakes, right? These can conceal IHL violations. They can manipulate responsibility. They can misattribute and create confusion about what's going on. There's also the selective nature about real-time evidence collection. So what's being collected, what particular events are being captured, what segment of the event. So sometimes there's an issue of a lack of context. And then there's just the need to filter, authenticate, and corroborate just a vast quantities of user-generated evidence. And on top of this, you have risks of algorithmic bias, discrimination, things that are associated with various digital technologies like facial recognition software, which was discussed by a previous panelist. So they raise a series of challenges as well as opportunities. So in the time remaining, I want to turn to the relationship between digital information and narrative and its relationship with courts. So the quantity and ubiquity of digital information contributes to the construction of narratives about armed conflicts. And narratives play a role in various respects. It's a multidimensional role. They can create pressure or incentives on courts, tribunals to act, to investigate, and to prosecute international crimes, as well as to frame and contextualize their actions. So take a couple recent examples, narratives about Russia's aggression, atrocities in Ukraine. We heard before about the forcible transfer of children, one of the war crimes, had supported the issuance of the ICC's arrest warrants for Russian President Vladimir Putin and other senior Russian officials. Likewise, narratives about Israel's conduct of the war in Gaza created pressure on the ICC to seek arrest warrants for the Israeli Prime Minister and Minister of Defense, for war crimes and crimes against humanity, as well as for arrest warrants for leaders of Hamas. So the narratives that digital information helped amplify helped to bolster and frame these actions by the tribunals. Narrative is also an element of international criminal trials themselves. in addition to providing its evidentiary value, right, to provide evidence against a particular defendant, to link a particular defendant to a crime, they can provide, trials provide a historical context for and record of atrocity crimes. And none of this is new, but what digital information does and digital evidence does is it amplifies this pedagogic function. There's simply more information to draw on, and the tools or the technology to analyze that information have increased exponentially. So in that respect, digital information supports courts in their function of creating an official record, and courts play a role in resolving disputes. They're factual disputes about a range of armed conflicts, what's happening on the ground. For example, in Gaza, whether if it's a strike on a hospital, is that you have one side evidence supplied by Israel, or Hamas or other groups, and you have evidence on the other side. Maybe it was being used, Hamas was using it as a military base. So you have a base for military operations. So you have digital information on a large record that's out in the in the environment and is available publicly. And courts potentially play a role in resolving these disputes and resolving disputes over contested narratives about conflict. So that's a potential. At the same time, we have narratives outside of courts. As everyone knows, international criminal prosecutions face a number of obstacles, legal and practical, as Ukraine demonstrates. And even when trials move forward, they can often take years to complete. So narratives about atrocity crimes can fill the gap in the absence of or in the space between trials, shaping how conflicts are framed as they're being waged and how they're memorialized later. And again, none of this is news. Has always been the case and the issue with narrative, but digital technologies have amplified narrative's role in the absence of trial and potentially impacted politics and policy. So while you don't have prosecutions of at least senior Russian officials for Ukraine, you do have narrative and efforts to use narrative playing a role in, for example, trying to provide and maintain military assistance and support for economic sanctions. That said, well, these are some potentially positive roles that narrative can play. There are also risks. And I'll just point a couple of those out and then just conclude. First of all, information that turns out to be false or misleading can cause misattribution of legal or moral blame to a particular side or a particular individual. So that's one issue. So if you don't have, you have a lot of information, but sometimes that information can lead to misattribution of responsibility. Also, when courts fail to act in the face of digital evidence and the massive amount of evidence about atrocities and atrocity crimes, it creates the expectation. Well, that information creates the expectation of accountability, and then when you don't have that and there are no consequences, it can create and reinforce cynicism about international law. There's so much information and you see so many pictures about what's happening, and yet there is no enforcement. So it does potentially undermine the notion of international law as having any effect. Just to conclude, digital information can strengthen international humanitarian law, not just by supporting prosecutions, but by magnifying its underlying values and norms. But if that amplification, after that amplification, there's no enforcement or enforcement doesn't follow, it can sow doubt about the universal nature of the values, their binding nature of the norms, it can corrode faith in international institutions, and it can fuel competing narratives. So in that regard, digital information's role in the construction of narratives can best be understood as an important additional source of support rather than a substitute for enforcement of international law, including and especially by courts. Thank you.
Thank you very much indeed, Jonathan. And again, many, many thanks to our wonderful panelists for their, I think, very clear, extremely well-structured presentations that I think create ample food for thought and also hopefully have already provoked quite a lot of ideas and willingness to ask questions. I will not be abusing my position as a moderator by expressing my views on the subject. We heard, I think, a vast variety of issues being raised, of issues of balancing between potential erosion of certain rules of international humanitarian law and the need to apply modern technology to counter a war of aggression. We've heard considerations again on how we balance the use of modern technology such as DNA testing and also trying to agree it with human rights safeguards and the best interests of children perhaps and considerations of privacy and so forth. And we've also heard very, I think, pertinent considerations about the advantages of using digital information and the expectations that the modern ways of looking at these matters will be used and the actual danger in adopting a more sort of orthodox position and ignoring the reality and ignoring the modern technology altogether. So I think there's plenty of things to discuss, and the floor is open for the first round of questions. Please, you were the first. Yeah, we'll collect a few and then yeah, please.
Thank you. Hi, I'm Caleb Wheeler from Cardiff University. One of the things that I don't think any of you really fully addressed, and I'd be interested in everyone's thoughts on this, is I think we all can see the value of digital evidence, but what we don't see as much is the weight that it's actually given in court. Agna, as you pointed out, it's generally, I think you said, is considered, it's acceptable by the ICC, but almost all evidence is acceptable by the ICC. The question really is, what weight does the court give it when it's making a decision? And I don't think we have any real examples of that. And so, I'd be interested, as I said, so it's more of a comment that I hope you guys will respond to, of, what do we do to make sure that this evidence that we can see the value of is being considered and being given the weight that it deserves, so that it is contributing to accountability, and ensuring that we're getting better convictions or acquittals in if that's the direction that the evidence takes us.
Thank you very much indeed. Well noted. And then, please, I think you were the second also to, yeah. I'm being slightly blinded by the light, so I'm apologies. So now I can see that it is Patrycja, but before I wasn't. So, sorry, Patrycja. Yeah,
no
you have the floor.
Patrycja Grzybyk, University of Warsaw, and I have a technical also question building on your question. You did mention, for example, the problem of the deepfake or that the information could be distorted. But did you find any example before criminal court or in front of the ICJ or arbitration court, where this was really undermined, that this is not me, or these are not my words, or this is just, this problem is just theoretical for the moment? Do you think, for example, that it does, because we know that in the ICJ in case of South Africa versus Israel, for example, Twitter was used as a source of evidence, but do you think should we bother that, for example, some of those accounts were official ones and some of them were private ones, not necessarily run by those individuals but by their assistants? Does it matter for the point of view of state responsibility and individual responsibility? And also, of course, I'm wondering how we can use our knowledge about AI and how it works. We know, for example, that there are some troll firms which, for example, generate misinformation. And we know, for example, that just before the commission of aggression or some atrocities, we could observe in social media a dramatic increase of certain information. Can we use those patterns which we observe in social media as a kind of evidence of the, for example, state responsibility?
Thank you very much indeed. I think these two questions complement each other so beautifully that we should probably take them now, and then we'll continue with the second round. So who would like to start? Yeah, please.
It is on probably, right? Well, it's indeed a very topical question. It's, of course, we have a lot of pictures, a lot of digital evidence coming from various sources. And the court, any institution investigating the case might be overwhelmed. What we really mentioned here is the pooling of efforts of society to collect evidence. You might have millions of pictures, right? Some of them are right, some are correct, some are fake. How you work with that. That's a big problem, of course, but with every technology comes also another technology to help, to assist with that. So I'm sure that technologies are being developed which also help to identify deep fakes, to sort the information, to try to select the one which is most relevant. What it gives to the judge, to the court, we don't see how it's taken into account, into what extent it's taken into account. But I think there is always a certain amount of information which already comes together and becomes a cloud which we can use the text being in the slide in front of me. It is amplifying the value expressed by that information, amplifying the collecting together, the knowledge, bringing into attention judges into judges' eyes what is happening in the particular situation. So one picture will not work, but maybe a lot will come together and then will have an effect upon the judge. Also, it's a moral thing, it's an ethical thing, it's also a push towards a certain decision that a lot of people are asking for you from that. It's also true. A question, the other one related to private accounts, official accounts that are also fake accounts, of course. It's again, a big issue to support. Private accounts will be used, of course, because a lot of citizens post on private accounts information, which is then downloaded to support the evidence. Officials published information usually is more cautious, but like the picture I posted on identifying soldier, right? I put the faces with whites in particular for the one reason, because I'm not sure if additional sources were used to check whether this indeed the correct identification, or maybe it's the person who is not guilty at all. Maybe he's not even linked to the breach of law which is being claimed. So it's very specific, but I think it's with a lot of type of evidence, especially with the pictures, with the videos which come into our eyes, that it arises.
Thank you, Agne. Julia?
Thank you for both questions. I just want to clarify that I didn't really look into evidence. I looked into DNA samples as a way for reunification and repatriation of children. So evidence was a very tangential issue. But just to know that apart from DNA samples, other information is collected for the purposes also of evidence. So witness statements, photographs, posts on social media, and DNA samples, in a way, even for repatriation, are used as a supplementary source to establish identity. So I assume similar approach we will see in evidence, but I didn't look specifically into this issue. But also, it would be curious to see, because there's not a lot of cases of litigated, especially in international courts, on forcible transfers of children. So just the subject matter is quite new But Ukraine already started litigating these cases, at least as war crimes, domestically, and they are cooperating with within the state authorities. And then also with Patricia's question, again, I'm not looking into evidence, but just to note, with my understanding with the ICC arrest warrant, it was largely based also on open source information that is posted by Russian government on, for example, Vkontakte, which is Russian Facebook. So even the example that I gave of Margarita Prokopenko, the journalists were able to locate her because there were photos posted by the wife of the member of the parliament on social media in Kherson with the head of Kherson orphanage. So Russian authorities, they do not hide, especially the crimes with regard to forcible transfer of children, because they also frame it as they're evacuating these children, they're saving them from the Nazis. So open social media posts, I would assume, would play a significant role in at least ICC prosecutions.
Thank you. Jonathan, please.
Yeah, I don't have too much to add. I think just a question. I mean, one of the issues around reliability that's come up or had come up initially at the ICC was regarding digital signatures and the ability to ensure those were accurate. I mean, it's an ongoing process in there, but the judges, I think, given that there are broad admissibility standards, have there's been increased emphasis on ensuring information is corroborated and is accurate, it tends to be, it can affect what kind of weight they have. But that's one of the general areas where there was issues or concerns around what the digital information that was coming in was accurate and verified.
Perfect. Thank you very much indeed. I'll just add that very generally that the rules of evidence before international courts and their actual application is a highly complicated topic, and the fact that we have now new types of evidence when we haven't really very much sorted out the ways of dealing with more traditional evidence makes the task of international courts even more complicated. And I'll just stop at that. So we are ready, I think, for the second round of questions. So the floor is open. If there's any wish to ask. I understand that we are heading towards the close of the second day of the conference, and you might not be, feeling sufficiently energized, but still, I think there is a question. No? Yes, please. Yeah.
Hello. Thank you so much for a brilliant panel. And I have a question to Agne about facial recognition. Is it possible to use photo or video from publicly closed profiles from social media? For example, if person closed the access to their social media, or for example, then when you presented, prosecutor's office will present it in the court, and then this person could say that this evidence is admissible because I don't want you to use these photos from social media to expose me or something like that. And for example, also from darknet, is it possible to use photos or video for comparison taken from darknet networking, for example? Thank you.
Thank you very much for your question. And if I may, I would like to slightly expand this also. As I mentioned, part of the problem, and I think that what was Agne referring to, and also what Julia was referring to, was exactly how do you balance the need to use this imagery, also information from social networks, some sort of surveillance and so on, with human rights involved here. So, what would be your thoughts on this balancing? And I would also then extend this to other panelists. So, Agne, you have the floor.
Yeah. So this was quite a concrete question, but the technology I was talking about, it's Clearview. What it does, it collects from all social media, it collects all the pictures you have ever posted there. In general, what you put on the internet is also accessible even if you delete it later on. So what it does, once you put your picture, it goes via the search to measuring your face, it measures your face, and then compares it with all the possible examples it has collected in its database. No one asks you if you want to have that picture there. I mean, no soldier who is identified there was asked, do you want me to use your social media? That is the controversy of this facial recognition technology. And I think many of you have read that Clearview has got several fines all over Europe. One being, I think, very recently, I don't remember, but certain a number of millions. Because it's, in fact, its database, how it's built, it's not really a proper way to approach human rights, right? But once we are talking about the war, right? Once we are investigating war crimes, and then do you really question, and to what extent you question how it collected the pictures to work as an investigative lead? You identify the person, but then you need to support that he was in Ukraine, he was in that concrete area, he was, I don't know, there was a witness who saw him. So it's not that facial recognition technology is a separate evidence. It's only a tool, it's a supplement which helps to work it through. And here, we don't accept evidence just because the database was collected from contact.ru and no Russian would like his contact.ru to be used in analyzing war crimes related to Ukraine. I think this, it's again, we are talking here about balancing. And this is the case where it's more important to identify the person and then to proceed with other evidences linking him to the situation. So that's my initial thought. Of course, if you are talking about private litigation, then the rules might be different and you might have a different situation. There are a lot of discussions now all over Europe about facial recognition technologies being used in CCTV cameras, right? That's a different. Here it's in peacetime, we don't want to be over-policed, we don't want to be controlled, it could be biased, it could breach our human rights in general, but here when you use it as investigative lead from already concrete pictures from the war zone, I think we should also accept that certain rights have a bit higher importance than a privacy right of posting your pictures on contact.ru or Facebook, yeah.
Thank you so much, Agni. Well, this is very interesting, I would say also, because every time someone says that certain rights are more important than other rights, you would have so much opposition in the room, no matter the audience, you know. But I think that's a very valid point. Julia?
Thank you. I mean, it is a difficult question of balancing human rights with new technology, but I would say that with regard to using DNA technology for family reunification, I think it's mostly lawyers who are very worried, especially about right to privacy and data security. From speaking to especially victim families and families that would like to be reunified with their children, they are ready to do anything to be reunited with them. They, again, I'm not speaking for everyone, but for them, being reunited with their children is more important, again, controversially, than their right to privacy. However, I should caveat it with saying that it is a particular situation because the war is ongoing and a number of children that were forcibly transferred are children of some high-up military officers in Ukraine, political leaders. So data security and privacy becomes also quite important on another level because it can lead to Ukraine generally losing the war or more crimes being committed. So I guess it also depends on who is the identity of the family members of children that were forcibly transferred. But overwhelmingly, at least from my experience, the families would do not hesitate to provide their DNA samples because they're really keen to be reunited with children.
Thank you very much. If you have anything, yeah. You're sure?
Well, I would just say, I mean, I haven't looked at that question as closely, but I just think it's simply, you know, you have to see how the right to privacy would apply, you know, it might apply differently in armed conflict, and the balance might be struck differently.
Yeah, thank you very much. I think that there is, you know, the difficulty here is not that we are only balancing, one human rights obligation against another human rights obligation. We also balancing obligations from different legal regimes. We balancing obligations from international humanitarian law, international criminal law, with certain considerations of human rights, such as the right to private life, for example, and also, and that I think makes it even more complicated. We balance obligations that are owed to different subjects, so to say. So these are really, I say, multidimensional things, and it would appear that we are rather far from having a universal answer, and it is highly likely also that each jurisdictional body would probably be looking, most likely, will be looking from its own perspective, and we may end up with rather different views. And I'm in the courts, not only UN special rapporteurs on different subjects, because there you can have such diversity of opinions, basically different views about completely opposing views about the same matter, which has happened many times actually. Well, one of the examples I think that what Julia was discussing is the best interests of the child, because then can you actually use the argument of best interests of the child to defend a forcible transfer that would go against a rule of international humanitarian law, which is most likely of peremptory nature? So that is another question that I think, well, I mean, for me, the answer is pretty obvious to be honest, but then I'm sure there will be people who would still insist that, well, I mean, let's not underestimate the best interests of the child, even though I would say they're not relevant here, almost irrelevant. But anyway, so that's another part of the conversation. Dear colleagues, we still have a bit of time. Yeah, please.
Thank you very much. Thank you to the three presentations. I would like to point to something in relation to the last presentation that I find very interesting. I don't know if it's a question or more a reflection, and I would like to have as well your opinion. You spoke about narratives and about politics, no, and about how judges as well take the decisions and how they can get influenced, right, by a public opinion created through these new technologies or internet and so on. And I was thinking in this case against Israel, because I was quite surprised that I don't know about the rest of the audience, but how quickly in the public opinion it was creating a sense that genocide took place, but also that somehow, at least this was my feeling, that this was easy to prove, right? And in Madrid, I had the occasion to attend a conference of the ambassador of South Africa in Madrid. And I asked precisely, because she spoke about this question, and I asked her precisely how the team opted for choosing the crime of genocide with preference over the crime against humanity, because for the first moment I was thinking that the crimes against humanity could have very probably, I am not an expert in these topics, but could have very probably much easier to prove and therefore to win, right? By the way, I make here a parenthesis because it has a relation with the issues that has been raising here. She was saying as one kind of proof of genocide, a photo or a video, I don't know if you know about it, I have not seen, where there is an Israeli soldier and he had the opportunity to point with the weapon to a very young Palestine and an older one, and he chose to point the younger one, right? So as a kind of proof of genocide. But anyway, I was reflecting when you were speaking about the fact that this decision is going to take many years, right, to take place by the court. And therefore, a general opinion is, in my view, right, creating that genocide is happening, and also, and I find this important because it's not only a narrative about the facts, but as well as a narrative about the legal considerations. So I am wondering if maybe in the long term, the judges may be influenced as well about this. And also I find interesting the relation between these legal discussions and also the political actions, right? That some states now recognizing Palestine and so on. So I thought that your presentation gave a lot of food for thought, so thank you very much.
Thank you very much indeed.
Thank you for the thoughtful response. I mean, I think, yeah, it's multiple, I guess I'm thinking on multiple levels. I mean, certainly with, I mean, I think the issue and was you have the jurisdiction, genocide being more difficult to prove, right? And the merits determination could take, many years. Look how long it took in the case involving Bosnia, right? So at the ICJ, so you have, but you have an effort for the court or desire for the court to do something to address the ongoing crisis, the humanitarian crisis. So so you have that aspect, and then you just have and the ICJ trying to sort of do something and prove that it had some impact and try to do something. So, but you have the kind of multiple. You have this sort of narrative about humanitarian catastrophe. You have a narrative about genocide, but genocide as a merits determination is difficult to prove and will take. It's far from being adjudicated. So, but in the meantime, the ICJ is responding, I think, to the narrative and the facts that are happening on the ground to try to do something. Yeah.
Thank you very much. May I ask other panelists if you have anything to add? Okay. Thank you very much. Any other questions, dear colleagues? Okay. So I think it's time that we should be gradually concluding this forum, for this Agora. Thank you very much indeed to all these three panelists and also to everyone who has contributed to the discussion with your thoughtful questions and with the views expressed also during this conversation. I think it's quite obvious that international humanitarian law, international law as such, as applicable to crisis situations, but not only, it must definitely react to the emergence of new technologies as quickly as possible. And this is the task for the lawyers, perhaps, for the scholars in the first place, and then, of course, for the decision makers. I think one of the recurrent topics, looking not only at this Agora, but also at other panels and other discussions that took place over these 2 days, is that there is a degree of frustration with our discipline, that it is really not adapting fast enough to the situation in the world, that it is in many respects losing its relevance, or at least seemingly losing its relevance, frustrating people who believe in international law and who have contributed to the cause of international law, to making this world better with the help of international law. So perhaps using the modern technologies to try and remedy some of the most egregious violations of human rights that we are living through, we're experiencing, is a good idea, and that is perhaps one of the main takeaways also from this Agora. Thank you very much. Enjoy your coffee, and until next time, thank you.